Good morning, good afternoon, good evening, wherever you're zooming in from around the world. Thank you so much for coming to this Global Chamber event. That's one that we haven't done before, but we have three people who are experts in this particular area of a topic that's important for anybody doing international business. And that is, how do you avoid disputes as you grow your business around the world? Invariably, there are agreements and a variety of other things that happen, and all sorts of hell can break loose, all sorts of problems if it's taken the wrong way and you don't de-escalate. Also, there's also plenty of issues related to how you write contracts and agreements up front, and I'm sure Jeff will be talking about that here, and he'll be kicking us off. Jeffery Daar is our attorney who will be speaking today. And then we have him supplemented with two trade experts, Rubby, Golo and René, René van Baardewijk, who will be talking about their perspectives from many, many years of trade. So let's start with Jeff. Jeff Daar is the senior principal at Daar Newman. Jeff is based in Los Angeles. He has served as city commissioner for the city of Los Angeles for more than 15 years. He's also been the chair of the State Bar of California International Law Section. He is a tremendous go-to attorney for international activities because he's done it all, he's spoken on it all, and we're really pleased to have you here, Jeff, to share your perspectives on this topic.
Great. Thank you, Doug, and thank you, everybody, for listening in. Let me start by saying this is actually one of my favorite topics, and I speak frequently on international issues. Why is it one of my favorite topics? Because I think it's sort of the glue that keeps everything together. I mean, all of us who are listening in and all the panelists, we all take a strategic view of our investments and our business. One of the things that I see frequently not done is taking a strategic view on how to protect your company when doing business with other countries, cross-border business. And that's what I want to sort of quickly focus on. And the key to me is, how do you avoid disputes and make your cross-border business transaction investments work as you intend? And that's what typically is what's missing. People will do cross-border, add that extra dimension of all types of issues I'll briefly touch on in my initial comments, and I'm sure throughout the program we'll speak on. But then when it comes to actually thinking through that added dimension and the strategy of how to make things work as you want is what often only comes up later on when something doesn't go right and your transaction doesn't work as you intended because you didn't think through initially how to structure it so that it actually will play out the way you wanted to play out for you and your business. So a couple comments initially. Each transaction, I will stress, is very different from every other one. One of the common mistakes I see is that everyone just treats one cross-border business deal to be the same as the next. And therefore, when it comes to the issues of how to make it work as you want, how to avoid disputes, how do you resolve disputes, people just do a cookie cutter approach when that's probably the worst thing to do because each deal is different from the other one. And to think that one is going to work is usually, what you did before it's going to work in the next one is usually not right. And that's a common mistake. And also, every time you do business with another country, or even depending on the country or region of that country, a lot of our countries are really large and very different regionally, things are different. So don't fall into that trap. So first thing, really need to do an analysis of the likely strategies for each side, not just your side, but as the other side is to how to avoid disputes and how to make the deal work. And what do I mean by that? Are you the party who wants to make sure that if you're to be paid, that you really will be paid, and the other side won't think they can get away without paying you? And how do you make sure that the way you structure your deal is going to make the other side not believe they can't be held accountable? Or on the other hand, are you the one who wants to be held less accountable or to have your assets harder to reach? And those all go to the heart of how do you structure things. You need to make sure that your team includes someone who has expertise in dispute resolution issues in cross-border transactions. One of the biggest mistakes I frequently see is people putting together domestic-looking contracts that are beautiful except for they have no validity when it comes to adding cross-border issues of other countries, other jurisdictions, other legal systems, taking consideration how to have resulting if you had to go to a arbitration or a court, how to have it be enforceable. And that's missing usually. And you could have the most beautiful contracts, but when you look at them with the eyes of, okay, do they fit this transaction? They're not even worth the paper they're written on. And we'll probably get a chance to share some of those examples. And also, maybe the biggest mistake I see is that cookie cutter approach. Everyone thinks that when they're doing their deal, the last issue to talk about after you work out your deal points is the dispute resolution issue, the ones we're going to be talking about, which are the ones that hold the deal together, hopefully, for you. And if they're done last, at that point, you don't really have much negotiating power left. And so if it's important for you to structure things so they work as you want, if you don't put those dispute resolution issues in the front part of the negotiation, at the end, you may have no power left to really get it to be the way you want. And that just seems to be one of the common things. So just a couple quick, because I don't have a lot of time right now in the introduction part, some basic contract considerations. Because of the international dimension of your transaction, you're going to want to multi-check against possible ambiguities, because there are so many more ambiguities that can come up from language, different legal systems, cultural differences. You want to make sure that you're not falling into that first trap. You want to make sure that you take the time to make the contract work for that added international dimension. And you want to avoid the tendency, because I'm a lawyer, I'm maybe the one who implements deals, I help negotiate the deal, but I'm not the decision maker at the end of the day. It's my client. And I see typically the deal makers rush the deal and shortcut the process, and then later on are not happy with the result. And so that's another sort of basic thing. A couple of things that may not come up today, but is worth just quickly mentioning. Does the Convention on the International Sales of Goods apply? Something to think about in every trade transaction. And real quickly, if you're not familiar, there's 84 nations that are members of the CISG or Vienna Convention, the Convention on the International Sale of Goods. And basically, other than some African countries, many of those, Ireland and the United Kingdom, if you have an international sales contract, the law of this treaty will apply unless you exclude it. And that's just one of those things that people often are not aware of until after the fact. And many lawyers aren't even aware, I find, around the world, particularly in the United States, of the treaty, as shocking as that may be. A couple other quick points. Language issues. Often, if you're dealing with multiple languages, you'll have a dispute over, or at least a negotiating issue over which language should the contract be in. And if there's more than one language, you really need to be careful to make sure it's clear what language controls, because you'll often have a contract with maybe one language on one side is a way to do this, another language on the other side, or even three languages. But the mistake I see is people don't make it clear which one controls in the case of ambiguity, since translations are subject to a lot of unexpected results. Also, make sure that if there is a translation, that it actually says what you think it says for the same reason. I've had, I'm the one who sees all the things that go wrong. That's one of the things that often goes wrong, surprisingly. Last thing I just want to touch on before we get to discussions on my part, some of the big strategy considerations to think about. What choice of law do you have for your contract or your deal? You need to know the differences between the possible laws rather than just assume that one will work for you right. You want to consider consulting with local counsel in those foreign countries. I get around that because I'm a California lawyer, but I do work all around the world. I work closely with lawyers in easily 30 plus countries where I have people I talk with frequently in the past days, would eat and drink with and have worked with. So I can very quickly, depending upon the level of what I need to know about a place, usually get that information almost immediately. And you need to have that ability to have, when needed, make sure that what you're doing will fit where you're going to be. And then consider who's most likely to have the dispute in your contract. Because again, for the issues I mentioned earlier, if you have a contract that requires someone to pay, but they know better than you that the contract doesn't really work for making it enforced, good luck in getting paid if there's somebody who has a choice of, do I pay you or pay someone else at the end of the day, and I don't care about the contract anymore. Would the choice of law you pick even be enforced by the country you pick, which is going to be a venue issue we could touch on? And if there is no choice of law provision because you couldn't work out one or you forgot to put one in, what law may govern by default based on where the venue of a dispute may be? And again, my goal is to have people avoid disputes, but it's knowing how these things play out, and the other side maybe knowing it's not going to play out in the way you think it will be is what doesn't make the deal work the way you want it. And I'm going to end for now, and we'll hopefully have an opportunity to touch on a lot more of these types of issues.
Thanks, Jeff. I do have a couple questions that have come in, and so I encourage you all to either send a question to info@globalchamber.org, and thank you for those that have. You know the process, so thank you. Or put it in the area here, the chat area or the question area, and we'll get to that. If we get too many questions, we'll process them offline, so don't feel ashamed that if your question doesn't get answered, we do end up usually answering them along the way. So the first question, Jeff, is you mentioned about every deal being different, but on the other hand, when you're writing a contract, ideally you want some similarity or commonality of contracts. And so how do you resolve the fact of deals being different, but ideally contracts having some level of uniformity?
Good question, because obviously if you're a company that, and I do help with this and reviews of this all the time, you want to have some, usually for common transactions, the same contract, so you know without having to look at it what it provides, right? I mean, so that's a good question. However, if I'm doing business with another country, and that country, for example, or the party whose assets I would want to make sure will be accountable to pay, I need to look at, unfortunately, the specifics of where they're located. So the venue for the dispute may or may not be where usually everyone likes their home turf, but you may not have that negotiating power. I mean, if you're dealing with Microsoft or Amazon or Apple, you're not going to have much negotiating power likely. But if it's a typical transaction between you and someone else, you're going to want to pick your favored, venue. So where you go, and we haven't talked yet about, do you want arbitration or litigation? But you do need to make that customization, because I'll give an example. If I'm doing a deal with Ukraine, and it's a software development. I've had this come up, software development. Ukraine, unlike a lot of countries, if it's not a native language, it's not going to be enforceable in Ukraine. And then the question would be is, if you have a contract that says, because this is the way it is with every other software developer, that venue will be in my hometown, let's say it's pick anywhere, London, and it'll be by arbitration, and we'll be provided for which arbitration provider. And we could touch on later why arbitration over litigation may be a more predictable result for your company if you ever had a dispute. But in the meantime, if you put that in, I've come to learn that in the Ukraine for intellectual property won't even recognize that other countries have jurisdiction over intellectual property developed in their country. So if you don't think that part through, you have this wonderful contract, but it won't work if you ever actually had a dispute with your developers claiming a right to the software they developed, a moral right or something along those lines. So that would be an example. So you want to try to have commonality as to how your deals work, but you have to customize them, or at least think through, should I customize them when you're dealing with different countries, different potential regions? And again, part of it's going to depend on your ability to negotiate and control the transaction. If it's equal, you may have no agreement on where disputes be done. The other side may want their home turf, you want your home turf. So unlike your contracts where you can just get people to agree with you, you may have to then come up with either a neutral place that no one really likes, but no one objects to, or reciprocal type of dispute venue where if you agree that if I sue you, I have to sue you in your home turf, and vice versa, to make people not want to have disputes. But there's a lot of different things you need to think through and customize. So you standardize as much as you can, but when it comes to the key part for making the deal work, when it comes to the cross-border aspect, you do need to customize it. And you want to come up with one that works for you generally, but you got to look at each one, because each one's going to be different, as the example with Ukraine.
Got it. That kind of relates to the other question that came in, and that is, you mentioned about the possibility or the problem when people put the dispute resolution issues at the end and leaving it to the end. What did you mean by that? Is that like the specifics of how disputes would be resolved? That kind of a thing? And you're
Sure.
saying that that should be in the early conversation as the contract is being put together.
So typically when you put together a contract, everyone's negotiating power, unless you really got all the power, then it's not as important, but that's probably not that relevant unless you're a mega company. Like an Apple or somebody who just, you do business with me my way or no way. Most people don't have that luxury, right? So the issues of venue, where is the venue heard? Because, no one likes to be home turf, meaning if you have to go to a place that you don't believe is going to be favorable to you, or be more favorable to the local company, you may not like that. If you have, say, the choice of law issues, which legal system will work? And that could drastically result in different ways of a matter will play out if you ever had a dispute. And again, knowing how that plays out will make people do as you want them to do and be predictable, or think they can't be held accountable. And the one thing I haven't touched on, enforcement of any result. If you can go to the trouble of getting a judgment because someone never paid you, but the way you did the transaction, and I'll tie this to the issue of timing, isn't going to be that relevant because you have your judgment, but you have to now enforce it. So you have to go to where the assets are. And if the other side knows that the way you did your transaction makes it less likely that you'll be able to enforce a otherwise good looking judgment on paper and wherever it came from, then it's still not worth much. So you need to go through and think about those things. And if you don't do those as part of the negotiating of the key points of your deal, most people's experiences by the end of the deal, no one has really, unless it's, you're the dominant part of the deal, you don't have as much negotiating power, and it's hard to get some of these key points for purposes of making the deal work as intended, actually work the way you want, because you just don't have any power left, and it just falls through to whatever may happen. And that could be what, at the end of the day, makes the other side smile when they think that this isn't worth anything, because so what? You get a judgment against me. It'll never be enforced where I have a single asset, as one example. And international arbitration, which we'll touch on, may be something you want to negotiate, but if you don't do it in a strategic way, you won't get the advantage of it. And the advantage of an international arbitration, unlike a judgment in a court where you don't have an arbitration agreement, would be that there's no treaty that makes it predictable more than less, that it'll be recognized wherever the assets may be around the world. And that's one of the reasons, we haven't talked about it much yet, but why choosing an international arbitration provision, which again, you have to negotiate, it's not cookie cutter, may be critical as to having someone believe that if they don't pay, at the end of the day, they'll be held accountable, so they better perform and the deal works as everyone wants it to be.
Got it. Makes sense. Thanks for the answer. Thanks for the question. Keep the questions coming. And our next speaker is Rubby Golo. She's the founder CEO of Global Trade Consult. She's also the executive director at Global Chamber Accra. So she's zooming in today from Ghana. And so we really appreciate, Rubby, all the things that you do. You've got some great experience, and we'd love to hear some practical experience and advice from what you've done in international trade there in Accra and across Africa.
Thank you, Doug. It's a pleasure to be one of the speakers. Thank you so much for the opportunity. If I can have my slides on.
Sure.
So Jeff has covered all the points very well. I'm not a lawyer, but I just want to share some few tips on the lessons that I have learned in course of my work over the years. And so the first one is you need to know your legal obligations as a business. So before you start a business, or if you're already in that business, it is a must for you to be aware of what sort of legal obligations apply to the type of business you are venturing into. It is also important to understand and comply with these obligations from the very onset. So if it means you have to register with appropriate departments or government institutions, get that right from the very start. Next slide. Seek for help. You should not wait for a problem to occur. I believe that seeking help and feedback from your lawyer, the experts, the accountant, professional business advisors, to ensure that you have a good system in place in order to minimize any potential disputes in the future. It is always good to touch base with people who have ventured into that kind of business and be able to pick some ideas from them and some tips before you venture into those business. Next slide. Also, I also realized that building a good communication and relationship with your customers and suppliers is key. In doing that, it helps you to avoid a lot of disputes, where sometimes you are in a conversation, you don't have any records, it's just a passing kind of discussions, and you don't have anything in writing to be able to cover your back. And so making sure that you know how to collect those feedback and use those feedbacks, it's very important. You must be honest with your customers. I mean, if you go wrong, you are wrong. You have to accept that and find ways of resolving those issues as quickly as you can. Next slide. So another thing that I've observed, I mean, is if you don't get the right staff in place, you can land yourself into trouble. And even when you have those staff in place, it is very important that you develop complaint handling processes for your staff so they can follow. I've had an experience where a client kept on going back and forth with email exchanges with my particular staff, and I had to step in because that particular staff was unable to follow the lay down procedures, and it actually resulted very nasty. So it's one area that I think people need to pay attention to. So when you are recruiting staff, you need to ensure that they are well trained and they do understand your business and the difficulties that come with those your line of business. Next slide. Now, Jeff has said so much about the contract aspect. One thing I've realized is we don't take our time to read through the contracts before we sign them. I will want to encourage everyone on this call to ensure that whatever sort of contract you are entering into, you read word by word. If you are not sure of the legal terms, seek legal advice or professional advice to ensure that all the terms are clear to both parties. Do not rely on information from other parties as to mean an effect of a contract. Next slide. Be organized. Keep copies of all your signed agreements and contracts. One thing I've realized is in Ghana in particular, most people do not like to keep data. And when you ask where is the document to support this, they are not able to produce it. I've had an instance where a UK client asked us to follow up on a government project with an outstanding balance that they needed to collect from the government. And you'll be surprised that the government officials came back saying they don't have documentation on that particular contract. And in this part of the world, most of the time you get to hear that documents have been destroyed. And so it is very important that you keep paper copies. If possible, you could have electronic folders created to keep very important documents locked up somewhere. So what we did was this particular ministry said they didn't have the details. Luckily enough, we kept one on our file, and then the UK company also had their copy. So when there was a change of government and they had new officials in that ministry, they couldn't trace a document. So because we had a backup, we were able to tender that in, and that kind of helped the process of the client claiming their monies back. So it is very important that we keep those documents very close to our hearts and ensure that we have them handy when the time comes. So those are the points that I want to put across. That's my contact. Should anybody be interested in exploring Ghana as a potential market for their products or services, please do give me a shout and we'll look to support you.
Thank you, Ruby. Really appreciate it. One quick question before we move to the final speaker. You mentioned about employing the right staff, and you talked about training. Could you talk a little bit more about what does that mean? Are there certain things that you're looking for, and what do you include in the training? Is it kind of basics on professionalism, or do they need to know the contract? You know, what are some of the things that you've learned that you need to make sure that you look for and that you train for?
Okay, so what we did was we actually subcontract that element to our legal partners because they are the experts in that area. So we organize a workshop for our staff to advise them and to train them on how to enter into contracts, what goes into it, what they need to look out, how they need to negotiate, etc. And so that kind of helped our staff to understand how to draft this kind of contract agreements.
Got it. So more around making sure there was a process around putting the contracts together so that it included the right things, that kind of stuff.
The right thing, the right wordings, etc. Sometimes you may want to just use your layman's terms, but when it comes to the legal aspects, Jeff will agree with me, it might not hold water. So it's always best to check it with the experts.
Fantastic. Thank you very much. Speaking of the experts, René van Baardewijk is one of those experts. He's based out of Barcelona. He's been doing business for decades. He's a Thunderbird grad, so that certainly adds to the credibility of René. He's the president at Rubby International, and he's also a global advisor at Global Chamber Barcelona. So René, thank you. You're on holiday. We really appreciate you taking the time. I understand that you are in the Netherlands today, just across the border from Belgium. And so thanks for taking the time and sharing some of your insights.
Yeah, thank you very much, Doc. And thank you for having me speak and explain a little bit. I guess in trade disputes and international business is basically what my company is doing. As Doc said, I have a company called Rubby International. It's a chemical trading and distribution company. My business is about, I would say, about 90% international. We have at the moment offices in Australia, in Barcelona in Spain, which is where I'm located, as well as in Rotterdam in the Netherlands. And each basically has its area of doing business. But it's all pretty much international. So to give you an idea, we buy in China, we sell to Argentina, we buy in Argentina, we sell to Spain, etc. So every contract, almost every contract is international. And if you can imagine, we do maybe on a daily basis, just the Spanish office, between 5 to 8 orders a day. So you can imagine there's a lot of scope for potential trade disputes. Now, in our type of business, there's a lot of commodity trading in there. There's standard contracts. You can imagine if you do 5 to 8 orders a day, you cannot have very long contracts. But of course, some of the people you're dealing with have a different idea. To give you an idea, if we buy from certain Russian producers, we usually get a contract both in Russian as well as in English. And as Jeff already mentioned, then of course, which would hold, in fact, in the case of a dispute. Fortunately, we don't have that many disputes. We try to do our homework before we go into a business transaction. Of course, once you know each other, it's pretty standard. And there's a number of standard expressions when you buy. A lot of our business goes via C. So you have the Incoterms, the FOB, CFR, which are international recognized. So basically, you know where your responsibility starts and responsibility ends. But even so, if there is a dispute, then of course that's when you really have to see how it all holds. And in a lot of the cases, you try to avoid going all the way there, because at the end of the day, if you want to continue the business relation with the customer, usually what you do is you try to settle it somehow before you go into court, where it costs a lot of money, and it's also it's the best way to continue the business afterwards. Of course, that's not always possible. So every year we also have some real disputes, and then then all those legal contracts and the contracts we have are not so big, but then it does become very important. And of course, we have in our standard agreements that the rule of law that when we sell a product, that the jurisdiction is in Spain if we are a Spanish company, or in Australia if we're in Australia. But the customer or the supplier will have its own, and it's really quite often then not so easy to find out as much as homework you do in advance. We do try to also prevent the disputes. We have all kinds of insurances. We have a credit risk insurance. That means that if the customer that buys from us is going bankrupt or whatever it is, that we have a risk for that. We have a marine insurance. If the boat collapses or something happens like that, we are insured for that. But of course, sometimes things are just not as straightforward, and then I can give you many examples. We had, for example, a couple of years ago, we had a dispute with a customer in El Salvador in Central America that bought a product from us from China of a certain product, but they stipulated a certain brand. And the product actually goes straight from China to El Salvador. It doesn't go via our warehouse. It goes straight from there, and it's all paperwork basically. Anyway, the goods arrived, and the brand, the product was the right product, but it was a different brand. So rather than, let's say, Coca-Cola, it was Pepsi-Cola. And this is where the dispute started, because the customer saw, okay, here I have a right case. And then you really try to make advantage of it, because of course, once we noticed, because we didn't know, we offered to get back the product and send the right brand. But he said no, and this product is now dangerous and it has to be destroyed. It was a food product, so very difficult to stand up. But anyway, our credit risk insurer, in fact, contacted their local lawyers in El Salvador, and they went there. But it seemed that the owner of the company was the nephew of the former president of El Salvador, who happened to be in jail anyway, but it gave you a bit of an indication. So the lawyer in El Salvador came back with a report. He said, well, you can go to court there. You may win, you may not even win, because this is a country where the rule of law is not always as strictly applied as you want to. But it's better to avoid, because it's going to cost you $25,000 or $40,000, and I think the amount involved was about $80,000. So anyway, the insurance company just left it at us. So we take our losses, and then of course the next year they increase the premiums to us. But this is sometimes some of the cases. When doing business internationally, you can try to avoid as much as you can. We work with local agents. We have a lot of local contacts in the countries that we work with. But even then, sometimes things happen that you cannot avoid. In China, for example, during the Olympic Games, or just before the Beijing Olympics, they needed a lot of raw material suddenly from Europe, which was the other way around. Normally, Europe imports a lot of chemical raw materials from China. Suddenly it was the other way around, because they needed to have everything ready for the Olympics. And we were sending, and it was no problem until suddenly they changed the law just by that. And we had like 20-foot containers in the ports in Shanghai and then all these different ports in China. And suddenly they were not allowed to get into the port again. And you can then try as much as you can, but the only thing is just try to get the material out there as soon as possible and try to sell it off somewhere with a loss, because you cannot go against that. That's just impossible. So even if you try to avoid it as much as possible, sometimes these things do happen. But I mean, we always try to get to know our customers and our suppliers that we work with as good as possible. And nowadays, via the internet, there's a lot of ways to have some investigations. Obviously, they have usually, besides the credit insurance companies, you work also with, you can get Dun and Bradstreet report. You can see how long they have been available. You can ask for trade references, and that usually gives you a good idea, because the companies that are serious are trying to keep a good record, because in the end of the day, if you're in this business for a long time, reputation is everything, and you can build a reputation. It takes many years, but you can destroy it very quickly. And also in our business, the word goes around quickly. So I guess that's also a good way of trying to avoid disputes, but they do happen. And that's our job basically also, is to in the countries that we do business, is try to get as much as knowledge about the customer, about the market, and so investigation and knowledge, and lots of personal visits. Learning the language, speaking the languages is very important in the countries you do business, because of course nowadays most of the people in the business world speak English, but if you do business in the French-speaking parts of Africa or in South America and you do not speak the local language, you do not hear everything you want to hear about a business deal. So it's still very important to know about that. I guess that's my 5 cents as far as experience goes. But it's especially here in Europe, of course, we are used to having a lot of cross-border business. I mean, a big country like the United States, of course, companies don't have to go as far outside if you're working in Europe, and especially in our type of trade, international business is the name of the game. So you have to be well prepared for the risk that occurs. Also things like exchange rate risk, if you buy in euros or dollars or yens, or you have to take that into account as well, because those are also risks that you have when you're dealing international. And if you are want to sell, of course the customer will give its conditions, and if they're used to sell in a certain currency, but they have already their existing suppliers and you want to get in, obviously you have to also offer them according to conditions that are favorable to them if they want to buy from you. So
makes sense. You mentioned something that we've heard before from the global tribe, that the world is a small place, meaning that, you know, if you're going to be problematic as a trade partner, it comes out, and so people know it. Unfortunately, you know, sometimes we do deals with people that are, you know, are somewhat problematic and we don't know about it yet, and so these things happen. So thank you for sharing more about some of those experiences. I'm wondering, going back to Jeff, based on what you heard from Rubby and what you heard from René, what are some of the things that stand out to you that maybe we should circle back and cover?
Sure. A couple of things I'll mention that it may or may not directly connect, but I think we should talk about briefly. And also, by the way, you know, the world is a small place, particularly with people who do cross-border business. And so at the same time, if everyone perceives correctly or not that you just cave every time there's a dispute because it's too much trouble, that could come back and bite you too. I'll just throw out. That's a dynamic that I often have with clients, is to when is it reasonable to settle, when not. One thing we haven't talked about that I strongly encourage, every deal in my mind that's cross-border, if you really intend for it to work as, you know, the words on the paper spell out, put in a mediation provision, a provision that requires, before any dispute escalates, that the parties agree to mediate. It also shows that the intent of everyone at the beginning of the transaction is that we're going to make it work, because we're going to, before anyone pulls a trigger on any of our dispute resolution provisions in our contract, we're going to be required contractually to actually sit down, have a neutral person help us avoid a dispute. And that alone may maybe enough just to avoid even having to do a mediation, because it'll force the parties to sort of informally talk before it even gets to the point of we need some neutral person to help us work it out. So that's something we haven't talked about. I think it should be in most agreements, particularly cross-border. Touching on, I also see it's in the Q&As coming in, arbitration and so forth. I'm in the United States where discovery really is amazingly, no stone is not turned. It's for people from other countries, scary, invasive, somewhat alien, expensive. You have to, everything good and bad comes out versus just providing the good documents you're going to use for a court or an arbitration hearing. When you do these things, by the way, just to put in the back of everyone's mind, one of the things that I have a practice of in the United States, meaning as part of my legal work, is for foreign disputes, which would appear to include, I'll put a little asterisk appear, but I think it does, arbitrations in other countries. So if you have a foreign dispute, foreign court, foreign arbitration, I can get you U.S. discovery for documents and even testimony to aid in your foreign court proceedings. And it's sometimes something that will fill in the holes of a dispute you have in some other country where there's somebody in the United States who has information, documents, or testimony. And the other thing we haven't really touched on is for most cross-border, but not all, I think international arbitration has a lot of advantages to build in. And again, that's when you want that negotiating power early on. So it's something that you make an important deal term versus an afterthought when you don't have much power left. And the reason why is there is a treaty that goes back to 1958 on international arbitration awards. So if you had to have an arbitration, and again, you want the way this plays out to deter someone from having your dispute, but if you have an international arbitration provision, and if you're dealing with the countries which are almost everywhere in the world, but for maybe Taiwan and a couple of places that are parties to this treaty, wherever your arbitration is, it's very likely that a local court will, at least in a predictable, uniform way, determine whether that arbitration award will be turned into a local judgment. And if you have a local judgment, you can get, likely enforcement against whatever money, assets that are needed to make you whole. And again, you don't want that to happen. You just want people to know that's how this will play out if they, play around with you and don't comply with your contract terms. At the same time, if it was a judgment from a court, because you didn't have an arbitration agreement, which is a contractual agreement, it's not going to be imposed on anyone unless you put it in your contract. The problem becomes you may get in your home turf even, because somebody did business with you, they probably will be subject to local jurisdiction. You can get a judgment against them, and I do this all the time around the world. How likely is it, even with the best planning, that a foreign court where the assets may be will sit here and actually agree to recognize and enforce your judgment versus come up with some reason why they won't? And that's a whole other strategy, but it's one of the reasons why when it comes to cross-border, the arbitration provisions, which you have to negotiate and you have to customize them. You don't want to necessarily, as much as I know everyone likes to have standard contracts, again, you may have reasons why your standard arbitration provision needs to be modified a little bit, such as what type of documents would you need to prove your case? And if you don't make sure that you have a way to get those documents in your arbitration, you may have a problem. Or if you're dealing with a contract involving confidential information like customer account information, trade secret information, will you need potentially a provisional remedy like an injunction to restrain someone from using your confidential data? And if it's in an arbitration, you want to make sure that you think through what you need to have in your contract so that it's predictable that if you needed such a provisional remedy, such as a injunction, a preliminary injunction, or some type of injunction, you'll be able to get it. I've been dealing this week on an injunction just to aid a foreign arbitration in Hong Kong, where I was able to freeze millions of dollars of bank accounts in the United States. But the contract that was underlying a very large investment deal made it really easy to make sure that there would be provisional remedies available, such as a freezing order in the United States on bank accounts for purposes of aiding a arbitration that will be pending in Hong Kong and related proceedings for provisional relief in the Hong Kong court, but it's the contract that allowed me to be able to get that easily versus if it wasn't in the contract right, it may have been a little harder to do.
Got it. Interesting. So a lot of thinking ahead. I'm wondering, going back to you, Ruby, you had mentioned about maintaining good relationships with the people that you have these contracts with. What's your experience with both arbitration and also mediation? And what are some of the things that you do to make sure that those connections are ongoing, that there are good relationships leading up to potentially resolving some of these problems without legal help?
Right. For me, I think in terms of arbitration, from the very onset, when the contract is being drafted, there should be a clear understanding where it will be held. If it's going to be at a local country of your partner or the other party, it should be clearly decided from the very onset. We've had an experience where people just copy old agreements without discussing with their lawyer. They think that it's similar to what they want to enter into. So they don't really look at the lines. They just copy and paste old agreements to suit any new contract. So for me, you need to sit down with this client and have that kind of relationship to discuss every detail of the contract. So that's what I've learned.
Okay. Renee, how about you? Do you do some special things to keep relationships going so that if there is an issue, that there's a clear channel between you and the person you're doing business with?
Well, yes. I mean, as I said before, we're constantly in contact with them, having visit them. Of course, at the moment with COVID, it's a little bit more difficult, but especially in countries with more difficult jurisdictions, like in certain countries in Central America or in Africa, I think it's very important to know very well who you're dealing with and to make sure that if a dispute happens, because sometimes, you know, goods can be held up or stuck in the port, and things need to be solved, and sometimes need to be solved quickly, because otherwise, let's say if you have perishable goods, you have fruit or something, and you can't have it wait in the port for a week or two, because you can throw everything away. So you need to have quick solutions, and then then it's so important to have a local contact that can help you solve it, and to have a good communication line. I mean, the jurisdiction, the Lord, that's of course always the last line of help, of course, and you need to have it ready when necessary. But of course, we try to avoid that as much as we can by making sure that we have good contacts in the countries we're dealing with.
Got it. There's a question on intellectual property, and maybe Jeff, we go to you on this one. How typically are those handled? And there's got to be a lot of case by case, especially you do a lot of work with China. You've got to be very careful with these.
Again, that's where you don't want to have this cookie cutter approach to your contracts. Sure. And when I touched on a moment ago about concerns of if you're dealing with transfers or use of your intellectual property, which may be the most important part of your business, right? Depending on what the nature of your business is, but often people doing IP transfers and licensing, that's really important. If you don't think through how you protect it if there's a dispute, an example, if here's an example I did a little while ago, so it's I could probably talk about it. I had a client who's looking to acquire, as part of a large telecommunication deal. A small piece was they were going to acquire this other company's call center, and it was a call center in Central America, and it was in a country where I personally knew probably the best key lawyers there, but I personally didn't know the answer to this without checking with people, and that is the obvious. If the local call center then absconds with all of the customer information, all the contact information, what remedies would you have? Because you may have a wonderful contract remedy for damages, maybe that may or may not collect on one day. In the meantime, what's really important is the information for the customer account information, other data information that was being in that local call center. So I had to go check, and I found out to my surprise, and this was in El Salvador, that it was just at that time, for the first time in 100 years, they enacted a law to allow for injunctions. And before that, there was no actual law on injunctions. And then I found that out. I wanted to find out for my client's protection before they got too far into this deal, how likely is it a court would then enter an injunction if they had to, because that would be the most important. You know, no one cares about the damages. You want to prevent the bleeding and whatever problems would result from someone running off with your IP in this case, or your trade secret information. And there was no yet experiences in the local courts, because I had somebody sort of do a survey because it was just too new. So that was part of the risk. I won't get into what happened next, but you want to have your eyes wide open when you do deals. And when it comes to how you even structure yourself, if a company's smart, they may structure themselves where if you're trying to get assets and the assets happen to be IP, they may make it really hard to get to that IP because that's the core of their business. And it's like peeling off layers of an onion the way they structure themselves. And that also goes into this whole mix. If you're going to expose yourself to the world by doing business as you need to, how careful are you that in worst case scenarios, you don't lose your, if that's your core assets like intellectual property.
Good points. As long as we've got you, let me follow up one of the other questions, which is cross-language contracts. How often do you write contracts that are either in multiple languages or separate contracts in different languages? When do you decide to do that?
For me personally, in my practice, because I generally have clients who do things in English, and I've done contracts, I've done arbitrations in Madrid Court of Arbitration, and so I've done, everywhere probably at one point or another something. Typically English dominant language, but often, depends on negotiating power. So for my clients, more often than not is in English. But if the other side, for example, says, it depends on who has more power, we want it also in Spanish. I've done contracts where I've had English on one side, Spanish, and it gets back to that issue of making it clear in the contract which language controls to avoid disputes. I've had so many not disputes, but uncertainty that is surprising on what is a proper translation of a phrase or even a word. I've had cases in French where French contracts were being resolved at a trial, meaning we couldn't get it worked out informally, and the phrase of best efforts to do something had two certified translations that differed as to how the extent of the best effort would be, which was the issue of dispute. And out in the middle of a long trial for a neutral court's expert interpretation came up with a completely different third translation, which became the controlling one because it was the courts. But who would ever think? And I had a case where in the middle of a trial, the term, and it was Korean language primarily, although everyone but me spoke Korean, the word of CEO versus chairman of the board came out different at trial than what we all thought it was, which actually on my side worked out very well, but it was quite a surprise. And you could see that the difference, and that was a key issue of what was going on in the case, whether somebody was chairman of the board versus a CEO, chief executive officer, is very different. But, at trial, this was the way it came out, and it was different than everyone thought, except for the judge who otherwise didn't know what the answer was, just heard that one. So it's very important to, if you don't have an agreement on which language controls, make sure as I mentioned earlier, what's in that translation. And even then, don't bet the farm that that'll be 100% correct, because I deal with disputes over, it's only a dispute because you have multiple translations of the same words and phrases. And so you got to just think through what the risk is and how do you mitigate it. And again, that also goes to if you're having a contractual arbitration, that you can craft exactly where it's going to be heard, so you know what the rules may be. You customize those rules to make it fit so that if you had a dispute, it'll work as best as you can for your side. One of the issues will be what language is the arbitration. Real case example, I had a client, US, was a local distributor of a big Spanish product. So it was a Spanish arbitration venue in Madrid, Court of Arbitration. The contract did provide for the language of the arbitration to be in English, but then had the odd language, and I wasn't involved in the contract. I was only involved in the dispute. English and also Spanish to the extent possible, whatever that meant, since everyone spoke Spanish in Madrid. The lawyers were all local lawyers. Initially, were all people in Madrid. And to my client's shock, that's when I got involved. All of a sudden, while the contract was clear that proceedings would be in English, for the convenience of the lawyers and the arbitrator, everything was then turned into Spanish only. And I had a client who, other than they had an engineer who spoke Spanish, somewhat Spanish, no one spoke Spanish. And so all of a sudden they were like, what's going on? We don't have no idea. And that's when I got involved and took over the arbitration. But it was, you know, the type of thing where if you don't put in what language, for example, and that's important to you, you know, you could be quite shocked. And when we talk about arbitration, you know, I'll just note, because it's recent, in Africa, when I mentioned that international treaty for recognition in a uniform way of arbitration awards, and Africa, the last country to join this international treaty, the Convention on the International Enforcement of Arbitration Awards, commonly the New York Convention, was Ethiopia earlier this year. And that became, I think it was the 33rd country in Africa to ratify this treaty. So that's how much for cross-border business arbitration may be a good answer, because it's, again, 33 countries in Africa are part of the treaty. So if you have an arbitration and you need to get it recognized in a country in Africa, highly predictable, at least you know what the rules will be used to enforce it. You still have to deal with courts, but at least it's more predictable than something where you don't have any treaty at all, which is usually the case with court judgments.
Got it. We've only got a couple minutes left, so I'd like to just hear briefly from each of you, maybe 30 seconds. Rubby, first of all, before you wrap up, in terms of the language, there's, I think, you know, English is the main language,
Yes,
but
English
I believe there's like 80 languages in Ghana.
Yeah.
So do you end up writing most of your agreements in English? And then do you have any closing comments before we wrap up?
For us, English is the main language and everything is written in English. So it makes it much easier for everyone. Yeah.
Okay. Any final comments, that some things you'd like to emphasize, or in terms of wrap up?
I think that as a business, you know, we can't avoid disputes. It will happen in our working life, but we have the chance of minimizing that if we put things in the right way. And so my parting advice would be document your dealings and ensure you keep those close to your heart, because a day will come you will need to refer to them.
Very important advice, absolutely. René, how about you? You work with a lot of different countries. I presume English is one of certainly the main languages. Any comments on the multi-language issue, and then any comments to wrap up?
Yeah, sure. I mean, obviously the Spanish office, and we also deal a lot with Latin America. So we do have an English and a Spanish version. We do have written in there that in terms of that in any dispute, English would be the legal language. But then again, that's how it is from our side. And as far as Rubby says, it's very important indeed to keep a trail of all the things that you have discussed with the customer or the supplier before signing the contract. I mean, nowadays everything is by email or all these things. So it's important to keep that in case there is a dispute, that you have the written documentation, as much as you sometimes also make deals, or at least we do in our business, sometimes just go over the telephone. But once we have concluded the deal, we always write a confirmation confirming what we have discussed. So you have it actually in writing. But again, the best way to avoid a trade dispute is to do your homework well, prepare yourself well, invest in the country that you're gonna do business with. Try to know as much about the local laws, or have a very good local agent. That is usually a good way to at least to try to minimize the conflicts. But there will always be some, because our business, especially international, is just, there's always change, but it's the best way to minimize it. Thank you.
Thank you, Jeff. Proactivity and getting the contract right at the beginning. That came through loud and clear in what you talked about. Any wrap-up comments?
Sure. Two quick points, maybe. One, be strategic when it comes to how you think through and structure your cross-border business and each of your contracts. You're strategic about everything else. Be strategic about maybe what's going to be the most important thing, making sure your contracts work. And then we talked about being proactive when putting together contracts. I frequently get brought in just to help with that part of make cross-border transaction work. That's sort of one of my specialties, regardless of where in the world it may be. But also for existing contracts, I do this frequently. It's healthy to have a review if they're cross-border and they're somewhat, boilerplate. To what extent do they make sense? Do they work right? Are they what you thought they were? And that type of after the fact, because you have new contracts modeled after it, may be worthwhile doing for a lot of companies.
Very good. Jeff Daar, Rubby, Golo, René, Van Baardewijk, you guys are amazing. You've been doing some great work over many, many years. Your experience is highly valued here at Global Chamber. We really appreciate your spending the time today to share these tips. If any of you out there are interested in getting a hold of anyone here and the information shared so far hasn't given you the access to that, please feel free to get to any of them through the Global Chamber directory. And if all else fails, send an email to info@globalchamber.org and we'll be happy to connect you. My name is Doug Brunke. I'm the founder and CEO of Global Chamber. We do a lot of really amazing things because our members are amazing, and you saw that today. Thank you all, and have a good rest of your day. Thanks, everybody.
Thank you, everyone. Thank you, Doug.
Thank you very much.
Bye.
Bye-bye.